Right. Now, your question is very relevant, especially given the current news and environment. So there's a lease agreement that was entered into with a foreign national. Now, the foreign national happens to work abroad, but has his family in South Africa staying in this property that he let. Now, unfortunately, given the fear of xenophobia and violence, this foreign national would wants to cancel the lease and wants to take his family abroad where he feels it's safer for them. Now, the question here from the agent is the landlord entitled to claim a reasonable cancellation penalty for early termination of the lease?
Perfect. So just for some context for this particular question, we are sitting here today on the 1st of July, and yesterday were a number of demonstrations in South Africa relating to illegal immigration. And so this matter of illegal immigrants within South Africa is prevalent for the time. We're not going to comment on that particular issue. We're going to stick to our particular issue. But in respect of lease agreements, obviously, there's this question, as we've received, from someone who's a foreign national in South Africa, and they're asking what are the implications of this particular thing. They want to get out of the lease agreement because of these demonstrations. Now, the first thing that we need to consider is obviously our favorite provision of the Consumer Protection Act, Section 14. And just to highlight a difference here when it comes to a consumer and a supplier of a particular service. So obviously, supplier is the landlord, in the circumstances, consumer is your tenant. Now, these parties, in terms of the Consumer Protection Act, have slightly different rights. Okay. A supplier, in terms of a lease agreement, is only entitled to terminate that lease agreement after giving 20 business days notice in the event of a breach of that particular agreement. Okay, so there has to be some sort of breach, a non-payment or something to that effect. And then they are entitled to give a notice. And if that breach is not remedied, cancel the agreement. This is different to a consumer in terms of the act. A consumer is entitled at any time to simply give 20 business days notice of their intention to cancel the agreement. And then they can cancel it, and that is subject to a reasonable cancellation penalty in the circumstances. So what's important to highlight about the differences of rights between these two parties is obviously there has to be a breach in order for a supplier to cancel an agreement. But the consumer can cancel at any time without reason. They don't need a reason to do so. They can simply wake up one day and decide, I don't want to have this agreement anymore. And the provision there is a reasonable cancellation penalty. So insofar as the question today relates to what's happening in respect of the inspective rights or questions about illegal immigration, that actually isn't a factor that needs to come into account at all. As a consumer, you are entitled to cancel the lease agreement without reason. Okay. The question then comes on, is this something, the current political climate, is it something that would entitle perhaps a tenant to cancel the agreement, but then also not be liable for the reasonable cancellation penalty? So is there some sort of justification? Okay. And there's two real ways we can look at this. The first is there are provisions generally in common law that relate to something called vis maior or causa fortuitas, which are acts of God which might prevent a party from performing in terms of an agreement. Okay, so when we had COVID, this was a much more prevalent question of, is this an act of God which would excuse someone from performing their obligations in terms of a particular agreement? Okay, in those particular circumstances, in particular in the commercial space, we've got case law now where the courts have interpreted as no, that's not an act of God which would allow this in the circumstances. And I am afraid to say in these particular circumstances, I would say it's even less of a situation where we can call this an act of God. Okay, this is not an overriding circumstance that would prevent the performance, in particular on individualized properties. This is something that probably isn't going to extend that far. And in any event, I think if a lot of our listeners are using substantive lease agreements, you're going to have provisions relating to causa fortuitas and vis maior, which would exclude that in any event. But that's obviously dependent on your particular lease agreement. So I don't think that we have a circumstance where there are these demonstrations around the country, that it's going to extend that far. In any event, in hindsight, as we're sitting on the 1st of July, a lot of the demonstrations went through quite peacefully, thankfully, and there wasn't too much disruption on an individualized basis for people, so it wouldn't extend that far. Then on the other side of this is obviously, in terms of the Consumer Protection Act, what it calls for is the payment of a reasonable cancellation penalty. Now, as we have dealt with extensively on this channel, what is reasonable depends on the circumstances of the case. The legislation does not go to say what reasonable would be in the circumstances. So you need to then look at, what do we think is reasonable in the circumstances? And that may include circumstances where, say, for instance, someone is being kicked out of the country, or their life is now being threatened in the circumstances. That could be a factor which you have to take into consideration, together with all the other factors that are applicable to this lease agreement. For instance, how long does this lease agreement still have to go? You know, what were the prevailing circumstances when we entered into this lease agreement? All of those things are going to play a factor when you then determine what is a reasonable cancellation penalty. So this is going to be a balancing act. Insofar as the question is given to us today, where they say, would someone be able to escape the reasonable cancellation penalty as a result of these particular demonstrations? The answer there is no. Because there's March on March or whatever is happening around the country, that's not a ground upon which reasonable cancellation penalties can be excluded in totality. Okay, definitely not. But are they a factor maybe that comes into play in order to determine what's reasonable in terms of the act? Maybe. Okay, and that's unfortunately the way lawyers work all the time. The answer is it depends. The answer is maybe. It's definitely something that could be taken into account in the circumstances. So if you do have a tenant who is doing this, obviously from the landlord side, you're gonna want to try and maximize your reasonable cancellation penalty in all capacity. But this is something that is a factor, absolutely, that could and should be taken into account if your tenant is canceling, if they need to, you know, to leave the country or whatever the case is. This is something that you need to take into account for that reasonable cancellation penalty. And it's another great example of how the legislation has been drafted, how they've left it open-ended, so that we can take into account factors such as this, which obviously at the time of drafting the legislation, the legislature would have had no idea that this was something that they had to anticipate. So really interesting case study here. Perfect. Thank you, Bruno, and we will see you again next week.
Have a great one.
Yes, bye.
Bye.